Welcome back to Time Served, the channel that's against obstacle you don't have to. And what is a fate worse than prison? Well, how about being a teen, having your second DUI, and you get this revoked? I'm not going to give you any spoilers here, but it is a fate that is lifelong and is way worse than prison. Don't forget to like and subscribe, set your notifications to all. Let's roll, nerds.
People are represented by prosecuting attorney Timothy J. Rukowski. On May 11th of this year, the defendant entered a guilty plea to violation of probation, and probation violation report has been prepared by Mr. Nathan Licht. It's dated May 12, 2026. Mr. Glaze, have you and your client had the opportunity to review the updated report?
We have, Your Honor.
Any additions, deletions, corrections, or objections?
The only addition that it would make, no corrections to be noted, but just by way of update, it notes that he hadn't completed the alcohol class. He has at this point completed the alcohol class. I do have that certificate that he provided to me.
Okay, we'll note that in the report as well.
Thank you. Just so the court understands, he hadn't had that scheduled for several months, and it was actually canceled by the program because they didn't have enough participants. So that's why it's really coming in here late in the game. Though it certainly could have been done earlier.
Understand. Also, there is a sentencing memorandum that the court reviewed as well.
Yes.
This matter. Do you agree with all that, Mr. Slavak, regarding the report?
Yes, sir.
No additions, deletions, or corrections other than what Mr. Glaze has stated? Mr. Rukowski, any objections to the report?
No, Your Honor.
Thank you. Mr. Glaze, anything you'd like to say on behalf of the client?
Absolutely. So as the court noted, I did submit a sentencing memorandum, providing the substance of my argument. And I'm frustrated. I'm sure the court's frustrated as well. My argument is very similar to what we said the first time we were here. While I always appreciate when my clients hire me again, I'm not in the type of business where I necessarily want to see clients over and over again. And Brendan's one of those clients. I think our first case was resolved in a way that was certainly beneficial to him. I think it was appropriate. I think justice was served. And through that sentence, there was a punitive measure initially with some jail time, allowed to serve on the weekends, allowed to keep his job. He went through rehabilitation. Of course, had the first probation violation, a little more jail time that time, but still kept on heightened status, and here we are again. And like I said, I'm sure the court's frustrated. I think at base, though, of course, the sentence has to do with rehabilitation and punishment. And as noted in my memorandum, he has completed sex offender therapy. The discharge from that program noted it was done with improvement. He complied with everything. Of course, his legal troubles subsequent to have nothing to do with sex offenses. So I think from the first sentence, that rehabilitation was successful in that sense. But obviously what we have here is an issue with respect for the law, respect for the court sentence, with Mr. Shaw having come before this court twice now with OWI offenses. With the second offense, he's entered a plea, admitted responsibility in that. He's due for sentencing in San Juan. I certainly think the court would be well within reason and would be appropriate to impose a punitive sentence. And that punitive sentence necessarily might need to be more severe than the last. But I think that removing him from HIDA, I think would be too punitive, to put it frankly. That's not just a limited sentence of months or even a year and a half, which is being recommended here by the probation department as far as incarceration. That would be a lifelong punitive sentence. It would be a sentence of stigma for the rest of his life. I think that that would be a step too far, in my opinion. Certainly well within the court's ability to do that, but I would ask the court not to do that. If he needs to be incarcerated to really send a strong message, then by all means, then I think the court should do that. But I would hope, and I know he would hope, that he would be able to remain on heightened status so that he can come back from this, do what time he has to do, get alcohol treatment, and get that issue under control. Seemingly, that is the issue that remains. The sex offense issue, I think, has been addressed, and I don't foresee that as being a problem in the future. So I would ask the court to not follow the recommendation of the PSI, sentence him to whatever punitive term finds necessary, but to leave him on heightened status so that he can continue to receive the benefits of that status.
Thank you. Does your client wish to address the court?
Yes.
Mr. Slava, go ahead, sir.
I would like to say that I understand what I did wrong. I take full accountability and I understand I have an alcohol problem. I never meant to disrespect the court or I apologize. I just hope that give what he did and look past it.
Mr. Rakowski, anything of the answer?
Your Honor, I would point out to the court sentences a lot of individuals to HIDA and gives them that opportunity to not have a criminal record. And at times we'll get people that will come back and the court will revoke the HIDA on the first violation. The court didn't do that in this case. The court also looked at the circumstances and said, well, we'll give you another chance. But the end result is that he has two new criminal offenses while on HIDA. The first time the court initially, when he gave Mr. Schlabach HIDA, said 16 days in jail, can be served on the weekends, even working with him because he had a job at the time. And then he picks up this violation, so the court gives him 60 days. And then from there, after he does his 60 days, now he picks up another offense. The bottom line is that it's not, the probation through HIDA doesn't say no sex offenses. It says no violations of the law. And he violated the law not once, but twice. And because of that, I believe that that is based on what the recommendation was from Agent Lick. We ask you to follow the recommendations. I would point out that the recommendations are at the lowest end of the guidelines too.
A lot of times in criminal cases, there's always one side of the story. One side of the story typically is, well, you do the crime, you do the time. This is a violent crime, or this is a heinous crime, this is a terrible crime, and you have to be held accountable for it. And we understand that. The court understands that. It happens every day. But there's another side to the story as well. The other side to the story is maybe it's a youthful offender. Maybe he was or she was in a situation where the collective thought process was gone and you were just acting, whether it be on impulse or because of substances or just flat out just, for lack of a better phrase and no disrespect, brain dead. It happens. People make mistakes. And this court, along with other courts around the state, have been giving individuals opportunities to better themselves. And, you know, no one wants to be known as the hanging court or the strict court or this. Every case is different. Every single one is different. And the idea is to impose a sentence that not only sends a message, but looks at reputation, looks at other factors to come up with something where at the end of the day, you learn from it, you move on from it, and you never do it again. And the underlying offense here is significant. And we have a very young man in front of the court. And so there are times that in cases like this, you have to look at the whole picture. You just can't look at a snapshot in time and just accept what one party says over the other party. You look at the whole thing. And this court has always believed in rehabilitation. The reason is, at the end of the day, again, the individual, let's be honest, the cost to the state in housing individuals like this, the burden upon law enforcement, the burden upon the community, the threat to the community, all this plays into account when a court has to fashion an appropriate sentence. And Mr. Glaze, on behalf of Mr. Schlabach, has done an excellent job in getting Mr. Schlabach in the right direction. He made a terrible, terrible mistake. But as a result of that mistake, there was some learning behind it, and he was given an opportunity. And that's what Holmes Youthful Trainee Status is all about. The idea of Holmes Youthful Trainee Status is to take young offenders who make dumb mistakes, no disrespect, dumb mistakes, learn from them, be productive, and move on. And as Mr. Rakowski stated, this court does it a lot for youthful offenders, first-time drug offenders as well. And the reason behind it is, you know, we can just throw them in jail or prison, throw away the key, but what's it helping? When that person is released from a jail or released from a prison facility, is there anything that helped them so that they don't reoffend? In this case, the probation violations are unrelated to the initial charge and plea that was entered in this case. And from the court's perspective, above anything else, this court does not like the idea of yanking someone's HYTA or 7411 status, whatever it is, even diversion on domestic violence cases. It's not happened just once, but it happened twice here. And both violations involve substance use. And on one hand, because it's unrelated, there's a possibility, well, you know, maybe because it's unrelated, we should continue this. But here's the problem with that. What does this court tell other people who get HYTA status or 7411 status and they toe the line and they work their tails off and they sit back, learn from it, I'm not doing that again. Now, in cases like this, if it had been merely consuming alcohol, that's one thing. But consuming and driving, that's a violation of the law. And the court cannot turn a blind eye to that. Sadly. And the court, frankly, in this case and other cases, is disappointed. I'm disappointed. Personally, I'm disappointed. Because I don't want a youthful offender who's made a dumb mistake, no disrespect again, to face incarceration, lifelong stigma based upon the conviction, and a conviction, frankly, that is the scarlet letter, so to speak, upon an individual when they try to turn things around, be productive. But what's a court to do when you're given all these chances? And it's disappointing. It saddens me. It's sad to me personally, because I could be on that side. I could be on the other side of the podium. And frankly speaking, probably after the first time for me, I would probably be in a different state as well. But it's Fisher cut bait. And at this point, the court has extended as far as the court can extend. It will be the sentence of this court that the HYTA status is revoked. Sadly. Criminal sexual conduct, third degree conviction enters. Unsuccessful discharge from probation. He's to register in the Michigan Sex Offender Registry Act, comply with all requirements of the Act, and all the rules pertaining to it. And here's the difficult one. Defendant is committed to the Michigan Corrections Commission, placed in their custody for a period of 15 months to a maximum of 15 years, credit for 85 days previously served. My duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, the court will assign counsel form of public expense. Each condition will receive a questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Mr. Schlabach, I'm sorry, but the court has to do what the court has to do to be fair to everyone. And at the end of this, after you served your time, I hope that you learned from this, and I don't want to see you in this building again. No disrespect again. I wish you the best.
Chairman, just a quick question.
Go ahead.
Does the court, one of my requests that were, if incarceration were to be a sentence, that you would sentence them to become correctional with other private inmates, does that have to be placed on the record? Is that something the court considers? Or is that something that is a matter of course?
I think it's a matter of course. And I think that would be part of the oath.
Okay, and does he go into custody today, or would you like him to report?
Today, reports immediately, remanded to custody of the sheriff. Okay, thank you.